Well, my apologies for my tardiness there. I walked down without my notes. I'm David Elwood. I want to welcome all of you to the John F. Kennedy Jr. Forum here. I'm the Dean of the Kennedy School, and I'm enormously honored that we have this program for you today. It's a remarkable moment. I should start, before I introduce our guest, however, by thanking Elaine Poupoulis from the COCOLIS program in Southeastern and East Central Europe for helping us put all these things together. The program, which was founded in 1997 here at the school, is designed to build bridges of communication and interaction of Southeastern Europe, and is to be commended again for its initiative in this forum and so many other things. So thank you very much, Elaine. Appreciate your help. Inspired by the notion that administering justice can contribute to reconciliation and moderation, as well as justice in the Balkans and beyond, we've invited Prosecutor Del Ponte here to address the Harvard community and share her insights. It's remarkable work she has to talk about. I would also like to thank the Harvard Law School Human Rights Program and the Harvard Center for European Studies for making this event possible. Again, your support is genuinely quite appreciated. This address by Prosecutor Carla Del Ponte is her first university address in the United States. And so I thank you for choosing Harvard and the Kennedy School for this historic moment. And it is indeed historic because 60 years ago next month, the historic Nuremberg trials began in Germany. And the trials sought to bring, with I think some real success, justice, truth, and some sense of reconciliation after the terror of World War II. And the prosecutor carries on this great tradition at these trials. As the chief prosecutor at the International Criminal Tribunal for former Yugoslavia in The Hague, she has shown that no one is beyond the reach of international justice. Indeed, her work on the trial of former President Slobodan Milosevic has made her one of the world's most visible champions of justice for the victims of war. Natasha Kandic, Serbia's leading human rights investigator and head of the Humanitarian Law Center in Belgrade, has described Del Ponte quite simply as a relentless fighter against the obstruction of justice. And at the core of justice, President Del Ponte's work is truth. I should also say that by seeking justice for all those who were the victims of war and genocide of the former Yugoslavia and striving to establish the truth, Prosecutor Del Ponte has helped begin the difficult work of laying a foundation for a lasting peace in Southeastern Europe. The work is remarkable, yet it's not the first time she's pursued and brought justice to some of the world's most dangerous criminals. She served as prosecutor in the International Criminal Tribunal for Rwanda from 1999 to 2003. During the 1980s, she prosecuted the most notorious organized groups in the world, including Cosa Nostra in Italy and the Russian Mafia. While working on the Cosa Nostra case, she narrowly escaped an assassination attempt in which half a ton of explosives were planted in the foundation of her home. Despite these dangers, Switzerland's former Attorney General has berated presidents, faced off with NATO commanders, and challenged the famed bank secrecy rules in Switzerland. Her work is hard, sometimes unpleasant, unquestionably dangerous, and yet she moves forward with an unwavering conviction, which motivates those who seek justice, comforts all those who've been wronged, and gives us all hope for the future. So I was just meeting with her. I asked her, at the end, what gives her passion, not only for justice, but for truth, and so forth. And she said one very simple word: victims. The victims, the one way to find hope and peace for the victims, as well as a lasting peace, I think, more broadly. So it is my very great honor, ladies and gentlemen, to welcome to the forum Prosecutor Carla Del Ponte.
Thank you.
Let me just, excuse me, one second. Let me run across these.
Dear Director Papoulias, Dr. Elwood, ladies and gentlemen, I'm grateful and honored to be called to address you today within the framework of John F. Kennedy's Forum of Harvard University. It is a world famous for its outstanding scientific and academic excellence. I will speak mostly about Yugoslav Tribunal in The Hague, the ICTY, but occasionally there will be references to the ICTR, Tribunal for Rwanda. These two ad hoc tribunals are tied into one legal system through a single appeals chamber consisting in 5 ICTY and 2 ICTR judges with location in The Hague. I will leave out of address issues of political nature like conditionality and cooperation of states, but I think that your questions later will be welcome. Allow me to begin with a somewhat philosophical note. From the perspective of Greek philosopher and critic Aristotle, I quote, "It is in injustice that the ordering of society is centered." In our era, globalization of every aspect of our life, and with experience of 2 devastating world wars of 20th century, his words could be logically extending to the following statement: "It is in international justice that the ordering of the world affairs is centered." Or shall we be more careful today and say should be centered? The Yugoslav Tribunal has served the purpose of international justice for 12 years. While principal armed conflicts stopped 10 years ago in Croatia and Bosnia and Herzegovina, and 6 years ago in Kosovo. From the point of view of the development of the international humanitarian law, even the establishment of the tribunal was a considerable success. In terms of accumulated wealth of knowledge, practice, and jurisprudence, indeed, both ad hoc tribunals for the former Yugoslavia and Rwanda contributed greatly to the cause of justice. The jurists from different legal, political, cultural systems have come together to participate in adjudication of criminal cases in the international courts, making a way for an international criminal law proceedings evolving into a kind of hybrid of major legal systems, unique and important. Institutions of international justice require full, complete, and absolute support of the international community and its main players. That is probably our most important and bitter lesson. Institutions like ad hoc international tribunals are simply powerless and unnecessary without such support and cooperation. Let me use here the words of your famous general and Republican politician Eisenhower. I quote, "So force can protect in emergency, only justice, fairness, consideration, and cooperation can finally lead men to the dawn of eternal peace," unquote. Solutions for peace imposed by force, based largely on diplomatic compromises and bare political pressure, are often in conflict with the purposes of justice and criminal responsibility and can clash with the interest of thousands of affected victims. Therefore, stable solutions can only be viable if justice is satisfied as well. ICTY and ICTR achieved remarkable results. Presidents, prime minister, ministers, senior military and police commanders, paramilitary leaders, public figures were indicted and appeared before the judges. It is undeniable that the human rights agenda and international justice have made tremendous progress, irreversibly impacting on policymakers. The Yugoslav tribunal acquired great authority in terms of developments in the Balkans. The condition of full cooperation with the ICTY by the former Yugoslav republics is an unquestionable factor in terms of their Euro-Atlantic integration. The legal power of the ad hoc tribunals mandated by Chapter 7 of the UN Charter is colossal, it is mandatory and theoretically all-encompassing. All states must obey tribunals' orders. But in reality, tribunals depend entirely on the level of cooperation of states and entities, not only in the Balkans. The lack of cooperation is often explained to us by difficult political situations, national security, or sensitive political exigencies. Of course, it is always difficult. There will never be a good time to execute warrants and arrest notorious public figures or provide sensitive documents implicating countries' involvement in the crimes. But the principles of rule of law cannot be applied with a delay key, kind of not now, not this mechanism. I would like to give you now a short outline of our achievements and completion strategy. First of all, the UN Security Council obliged both ad hoc tribunals to finish their work by the end of 2010, and my office has fulfilled the first benchmark of completion strategy. All planned priority investigations have been finalized in December 2004, and all the last indictments were confirmed by the judges and issued in the first months this year. We are supposed to finalize remaining first instance trials by the end of 2008, having 2 more years for appeal after that. The caseload of the ICTY clearly is too large to handle in the given time frame. And part of our strategy is to hand over or transfer some of our cases back to the domestic jurisdictions in Bosnia-Herzegovina, Croatia, and Serbia. My office already filed motions in 12 cases, which in our view might be good candidates for transfer to relevant jurisdictions. 5 of these motions involving 10 accused were granted, and cases are being transferred or prepared for transfer. When it comes to the tribunal's achievements since 1993, we have 84 indictments have been issued, not counting amended indictments. 162 persons were indicted by the ICTY. 126 persons appeared before the tribunal in different proceedings. 56 received trial chamber elaborate judgments. 56 persons are in custody now. 24 on provisional release. 45 persons received final sentence. At present, there are only 7 accused still at large, while 2 have been located and arrested in Argentina and Russia, both awaiting transfer procedure. A couple of years ago, we had some 30 accused at large. We are doing everything possible to have all remaining fugitives located and transferred to Scheveningen, including first and foremost, as you know, Karadzic, Mladic, and Gotovina. The ICTY accumulated impressive evidence, judgments, rulings and motions, documents, exhibit, witness statements, videos, transcript of the trials. Apart from the judicial record found in the judgments and transcript, the Office of the Prosecutor alone is in possession of more than 4.5 million pages of documents, more than 12,000 hours of video, audio records, hundreds of maps and other items. Not all ICTY collection was used in trials so far. What remains to be done is expected to be done together with and thereafter solely by the domestic courts, and the tribunal was never in position or expected to deal with all perpetrators and all crimes. In terms of our strategy, the ICTY is engaged in a program of training, seminars, and conferences for the local judges and prosecutors. We encourage the countries in the region to enter into regional, bilateral, or trilateral agreements concerning judicial cooperation in regard to the war crimes. The goal is, for instance, to overcome an obstacle of non-extradition of nationals in all former Yugoslav states. Prosecutors of the countries concerned have already started direct cooperation in terms of evidence and witnesses, and even some criminal cases. Special courts for war crimes were established in Croatia and Serbia. On 9th March this year, the War Crimes Chamber of the Court of Bosnia and Herzegovina was inaugurated, and it has produced its own first indictment and already received one case from the ICTY. The local war crimes trials are facing serious challenges: political interference, national bias, deeply embedded prejudices, and unsettled grievances being among the most complex. In the context of the former Yugoslavia, local war crimes trials will be carefully monitored, watched, scrutinized by various victim groups, nationalists of all sorts, neighboring states, and the international community. Since Nuremberg and Tokyo tribunals, it is the first time that the authority to prosecute war criminals is being transferred from international to national jurisdiction. No one can guarantee a success. However, there is no other way around. In order for peace and reconciliation to take firm roots, the core challenges in this region must be addressed at the national levels. Allow me now to say a few words about tribunal system. It might be useful to recall some of the important differences between the military tribunals of Nuremberg and Tokyo after the Second World War and the two ad hoc tribunals for former Yugoslavia and Rwanda. Using the words of the famous French politician Georges Clemenceau, it may be argued that military justice is to justice what military music is to music. But seriously speaking, the differences are indeed substantial. Post-World War II tribunals were military, they were multinational rather than truly international, and composed of the four victorious allies. The ICTY and ICTR were created by authoritative decision of the UN Security Council approved by the General Assembly. The war was over when the military tribunals were created, while the war was still raging in the former Yugoslavia when ICTY was set up. In Nuremberg, most defendants were in custody and all German archives and infrastructure were at tribunals' disposal, while the ICTY is still looking for some of the most important accused, now 7 at large, and still has no full access to the most important archives in Serbia and Montenegro. There were 24 accused in Nuremberg, while 162 are indicted before the ICTY. Military Tribunal of Nuremberg had only very basic rules of procedure and evidence, only 11 rules, and trials in absentia were permitted. Martin Bormann was tried in his absence. In Nuremberg and Tokyo, the death penalty was permitted and there was no right of appeal. In the Yugoslav tribunal, the rule of procedure and evidence counts now 159 rules. Trials in absentia are not permitted, and there is no death penalty, and there is the appeals chamber. Without making any sweeping armchair moral judgments, present-day standards would not allow international prosecutors to hand over lower-level war crime suspects for so-called debriefing to the victims, which meant certain deaths in the context of post-1945 Victor. And I refer here to a story of Arnold Weiss, recently published in the Washington Post magazine. The two ad hoc tribunals reflect a huge evolution in criminal justice standards. Draft ICTY statute was prepared mostly by common law representatives and in great urgency. After adoption of a common law model of statute, the drafters also adopted a largely adversarial form of proceeding in the first rule of procedure and evidence. The rules were designed as a common law contest between two parties, but rules of admissibility of evidence were more flexible in the ICTY. They allowed judges to order the producing of additional evidence supplemental to the evidence produced by the parties. There is no uniform civil law system in Europe, but some elements are inherent to civil law system, like responsibility of prosecutor, investigative judge, or criminal police to investigate both incriminating and exonerating circumstances, equally as well as the court's obligation to actively seek truth. These elements divide the ICTY from the civil law tradition. After first rules were adopted, more elements of the civil law were introduced, like confirmations that witnesses in the court are to be considered as witnesses of justice or witnesses of truth before the tribunal. Although a prosecutor is now expected to present not only inculpatory, but also exculpatory evidence. But there is no obligation on the prosecution to investigate both circumstances equally. Since December 1997, the ICTY judges established the Rules Committee with a purpose to amending the rules to make the trials more expeditious and streamline the proceedings. 35 times rules were amended or changed. Guilty pleas are allowed by the ICTY rules. This institution is foreign to the civil law system, where the admission of guilt is simply part of the evidence to be considered. However, this possibility was used by the prosecution as much as possible, all in order to speed up proceedings and resolve some deadlocks. One of the most serious burdens on the prosecution and trademark feature of the ICTY is the disclosure obligation. It includes disclosure as soon as practicable any material which in the actual knowledge of the prosecutor may suggest the innocence or mitigate the guilt of the accused or affect credibility of prosecution witness. One can hardly find the equivalent of disclosure in civil law, where defense has access to the whole investigation's dossier prior to trial. No system is perfect, and international jurisdiction is no exception. There are shortcomings in both systems. However, the ICTY experience shows that it is possible for the International Court to successfully and effectively prosecute serious crimes, violation of the international humanitarian law, using elements of both systems. There is no way to cover in one speech, even extensive one, all aspects of the tribunal's work, rules of procedure and law. Speaking about the tribunal's law, it is unavoidable to mention that one of the prerequisites to trigger ICTY's jurisdiction is to prove existence of an armed conflict. Only for the crime of genocide that is not necessary to prove. Crimes against humanity, as listed in the statute, shall be prosecuted only when committed in armed conflict of internal or international character. There is vast jurisprudence on the issue of proving the existence and nature of armed conflict, the nexus between the crimes and armed conflict. Genocide. Genocide is exceptional, specific, and gravest crime, which both ad hoc tribunals dealt with extensively. Let me shortly go back in history. Being informed about methodical, merciless butchery perpetrated by invading German forces in Russia, Sir Winston Churchill called the offense in August 1941, a crime without a name. In November 1943, Raphael Lemkin found the right word, paralleling homicide as offense of exterminating human groups, and called it genocide. Since adoption of the Genocide Convention by the UN General Assembly in December 1948, two ad hoc international tribunals were the first international courts to investigate and prosecute crime of genocide. And now, Genocide Convention is undeniably considered part of customary international law, as the Akayesu judgment said. According to some specific tribunals' rulings, the crime of genocide involves first, specific act as listed in the statute. Secondly, that such an act be committed against a national, ethical, racial, or religious group, specifically targeted as such. And thirdly, that the acts be committed with intent to destroy in whole or in part the targeted group. One of the most difficult issues is to prove specific intent, known in the Roman continental legal system as dolus specialis. It is specific intent that distinguishes the crime of genocide from the ordinary crime of murder. Says one of the court ruling, mens rea must be formed prior to the commission of the crime of genocide. According to the developed jurisprudence of the tribunals, intention to destroy a group can encompass acts not leading only to death, for instance, sexual violence against the female members of the group, and contributing to the destruction of the group can constitute genocide. As you see, there are very significant advances made in terms of development of the specific areas of the international humanitarian law and international criminal law. The post-Second World War appeal never again, unfortunately, did not work. Terrible crimes, including genocide, have occurred on the planet since then under the watchful eye of the community of nations. However, there is progress. First of all, existence of international courts. And just recently, within the complex reform process in the United Nations, specific measures were accepted by all nations in regard to the prevention of crime of genocide and other abuses of human rights. In Kofi Annan's words, member states express their will to act collectively through the Security Council when a population is threatened with genocide, war crimes, ethnic cleansing, or crimes against humanity. For the first time, governments spelled out that where national authorities manifestly fail to do so, the international community, acting through the United Nations, is obliged and empowered to act. The UN Security Council has already used once its power to refer a case of serious violation of international humanitarian law to the ICC, the Permanent Court, and you know it is the case of Darfur, and we were very pleased that also the United States participate to this decision. In conclusion, the creation and the operation of the two ad hoc tribunals have highlighted the inevitable conflicts between the tenets of international law and those of criminal justice. International law is essentially consensual, while criminal law, regulating relationships between the state and the individual, is coercive and authoritarian. Until the creation of these two tribunals, and ever since Nuremberg and Tokyo, it had always been assumed that this kind of international instrument could only be established by treaty, due to the preeminence of state sovereignty in international law. Creation of the two ad hoc tribunals emerged from a political consensus expressed by the Security Council of the United Nations that in some circumstances state sovereignty must yield to the superior interests reflected in international humanitarian law. Recourse to international justice mechanism in denunciation of individual criminal responsibility of civil, political, administrative, and military leaders in a war or internal conflict may only contribute in a modest way to the prevention of such conflict in the future. But it will certainly help to realize that there is no cause, no nationalism, not even national self-defense that justifies the massive torture, rape, and slaughter of non-combatants or the persecution of people based on race, ethnicity, or religion. This realization is vital, as, for instance, many Croats still believe that defenders of the country cannot commit war crimes, whatever they do. Many Serbs are of the view that they were defending Yugoslavia from secession and terrorists, and therefore any action is justified, while many Kosovo Albanians do not recognize crimes committed by Kayle as they were fighting for their freedom. Individual criminal responsibility and deterrence are the cornerstones of the tribunal, and international criminal trials are seen as a remedy against impunity. The failure to punish the perpetrator, especially leaders for the atrocities of the past, served to signal to the future leaders that they would also enjoy impunity. On a lower level, it is remarkable how much influence the past crime of the 20th century, not properly addressed in the former Yugoslavia, had on the fighters of the 90s in the Balkans. They thought to be called to avenge their ancestors. Therefore, the international justice mechanism, such as ad hoc tribunals, shall work hand in hand with the national courts whenever conditions allowed it. And that is exactly what we are doing now. Thank you very much for your attention, and I expect your questions now. Thank you.
Thank you very much, Madam Prosecutor. We now have time for questions. There are microphones located here, another one right there, a third one here, a fourth one there. Just a couple of reminders that we have time for one question per person. Good questions has three characteristics. It starts by identifying yourself, it is short, and it ends with a question mark. So with that, let me ask here for the first question.
Ms. Del Ponte, this is the second time I get to ask you a question today, and I do apologize for that, but this is a rare privilege, and I feel very passionate and strong about what I'm going to ask you now. There's no doubt that you've done some amazing work over the years, but there are also some unanswered questions. In the case of Macedonia, where ethnic Albanian insurgents, I will call them terrorists, took up arms against the state, you mentioned before that an amnesty had been given by the state to those people. This is true, but an amnesty cannot apply to crimes against humanity. I'm sure you would agree. So my question is, who is going to provide justice to the victims of the Macedonian civilians who suffered at the hands of these terrorists? Well-documented cases when you knew, The Hague knew, and my question is, why did you not take action against this, and who is going to provide the justice to these people, particularly given that these families, these victims, in the absence of The Hague, are supposed to go to the domestic courts when those very same people that were responsible for these atrocities are now sitting in government?
Yes, it's not a short question, but it will be a short answer, because, you know, ICTY have a mandate who is restricted, we have jurisdiction only about high-level responsible military or politicians. So, not for the executor for the crime base. In Macedonia, the case of violation of international humanitarian law, the commission of war crimes, of crimes against humanity, were not except one case, were not identified by a plan from ministers or generals to commit such kind of crime. The only episode was the former Minister of Interior, and we indict him, and he is now detained, and his trial will start in December this year. For the other cases, it's the national court who must handle that. And now, if your country pass an amnesty law, that is the political will. That is it is impossible for us to assume these cases. I know the problem because despite that we start this investigation because particularly we in the office of the prosecutor, we are against impunity. So we start this investigation, but we could not follow up because on the completion strategy it was not possible. So it depends on the national court, and it is under the principle of sovereignty.
Right here.
My name is Ozren Tošić. I was a former commissioner for refugees in Serbia during the late Prime Minister Zoran Đinđić. I must say that first I appreciate your presence here. You are one of the longest lasting figures, international figures. The others are gone long ago or are writing books. So I'm pleased to see you here. I wanted to ask you one question, and that is a political activity of indictees of a Hague Tribunal. First of all, Slobodan Milošević is present every day in Serbia on TVs, and not only him, but also other ex-politicians of Serbian politicians who are in Hague. And that has a lot of influence on political scene in Serbia. Also, the recent Ramush Haradinaj case, I will be short, was outrageously proposed that he is allowed to do a political activity
yes.
from the provisional
yes.
freedom that he was granted. What do you say? Where that comes from? Because that last case about Ramush Haradinaj came from Hague Tribunal. Thanks.
First of all, I must tell you that it is not in the power of the office of the prosecutor to allow or not the accused to have political activity. And of course, we are absolutely against that. And we were very surprised about the decision which is coming out in Haradinaj case, because the other 54 detainees can also ask to have political activity. We appeal against this decision, and until now the decision is suspended, so it is not allowed. But as I said, it's not in the power of the office of the prosecutor, unfortunately.
Right down here. Again, identify yourself.
Hi, my name is Tim Reed. I'm a student here at KSG, and I was formerly a human rights investigator in Rwanda, as well as a political affairs officer in the Congo. My question is regarding the Great Lakes region in the tribunal there. The tribunal only tried Hutus, and it cost approximately $1 billion. And you look at a lot of the people from the RPF who also committed crimes against humanity, were then later involved in crimes against humanity in the Congo. There were also about approximately over 140,000 people who were small fry, who were rotted away in very horrible conditions in jails in Rwanda, while the alleged masterminds have top-line conditions in Arusha. If you had to do it again and use those resources, would you change the distribution of resources to fund trials and speed up the process in Rwanda for the small fry? And what would you do to stop it being such a victor's justice? Thank you.
I have just a short answer to that. I was prosecutor during 4 years for the Rwanda Tribunal. I opened an investigation that was not against the priority genocide perpetrators, but it was from the other side, from the military other side in the conflict in '94, and that it is now in power. The result of that was that I was not reappointed as prosecutor for the ICTR.
Thank you.
Right up here.
I'm Daniel Koss. I'm working in Western and Central Africa right now on a number of issues, and I've heard a lot of debate going on about creating regional criminal courts. I think it's not something that is going to happen tomorrow. But regional criminal courts, like for example ECOWAS or so, creating their own criminal court. And there was also a lot of debate when the decision was taken to transfer the Darfur situation to the International Criminal Court. So I would like to know from you, what do you think is a trade-off between appealing to the International Criminal Court versus creating maybe several ad hoc tribunals in Darfur or Western Africa, Liberia or Congo, or I would like to know what you think about this trade-off.
The creation of the tribunal ad hoc was, as I said, under the urgency for what was ongoing in time, because the tribunal, the ICTY, was created during the conflict. It was not ended, and even Srebrenica genocide were committed during the existence of the ICTY, was created in '93. In Rwanda also, the tribunal ad hoc was created because of the genocide in the '94. So it was a reaction of the international community on what was appearing and so suddenly in this particular political momentum. After Sierra Leone, East Timor, they created, it was not really an international tribunal, but it was a mixed tribunal, so national with some international elements. And after the permanent ICC, the permanent court, the International Criminal Court, I think that all this solution for ad hoc tribunals, they are now no more needed because we have the permanent court. Because in fact the permanent court is now the court for crimes, war crimes, crimes against humanity, and genocide. And Darfur, for example, was assigned to the permanent court. I think it was just for the Security Council was just to choose the best way to organize, to have first tribunals who can deal immediately with the case. But now that we have permanent court, we have now the institution who have almost world jurisdiction. I said almost because not all states are participating, and unfortunately not United States.
Right up here.
Hi, my name is Luc Roulet. I'm a student here at the Kennedy School. My question is, how do you see what is your vision for the international criminal justice beyond these two ad hoc tribunals where you have been working? What are the challenges and the opportunities in reshaping our globalized community?
But as I said, ICTY, I think if we will be able, and I hope so, to have Karadzic and Mladic by the end of this year, I think that ICTY could be seen as a success for international justice because we have implemented fully the mandate of the Security Council. And now for the future, you have ICC, Permanent Court, and what is it is for sure the right direction in view of the implementation of international justice. But of course, we need that all states are participating, and not only the 100 and I don't know how many are they now. And another weakness point of the ICC is the principle of subsidiarity. Because the fact that the ICC can act and open an investigation only if the states are not doing nothing, it will be a little bit tricky. Because the force of the ICTY is and was because we have primacy. Once the prosecutor opens the investigation, the states cannot interfere anymore. So, but despite that, I think it is the right direction.
Right here.
Yes, my name is Glenn Ruga from the Center for Balkan Development. It is generally assumed, and I think you agree, that Mladic is in Serbia, being protected by Serbian security forces. Short of an actual invasion of Serbia to capture him, which I don't think should happen, I don't think will happen, what levers do you think we have left to bring him to the tribunal? And there's a distinct possibility that Karadzic and Mladic will not make it to the tribunal. And if that does happen, what do you think are the consequences for both international justice and for the former Yugoslavia?
First of all, I see from an opposite angle the situation. I think that Karadzic and Mladic will be brought to The Hague.
Aside from assurances by officials in the region, do you have any specific evidence?
If I have it, I will not tell you now. You know, of course, we have some information, and we work together with the authorities and with many intelligence services also, fortunately. But of course, we are not speaking about, and we hope that we have success. That is what we hope in our work. But I think that Belgrade finally understand that for the future for this country, arrest of all fugitives and full cooperation with us is a priority now in the political agenda.
Thank you.
Right here.
Hi, my name is Andrew Chadwick. I'm a student here at the KSG. You gave us a list of the successes of your tribunal, but is it not the case that the very existence of the ICC is actually a symbol of the failure of the international community to intervene timeously in conflicts, and an intervention that would save millions of lives and billions of dollars? So I just feel that justice after the fact is a very poor second prize to the victims and their relatives. So how is the ICC actually contributing to more interventionist approach by the United Nations and the international community to actually prevent the kinds of massacres that you are now trying people for?
But you know, the activity of a tribunal, it's not to prevent the crimes. If it is not that, for example, in the case of ICTY, that we will obtain next year the conviction of Milosevic, that will be an example for the future as prevention for the commission of that kind of crimes. But it's not that the tribunal as such is preventing the commission of crimes, because the tribunal is a judicial institution for repression, to identify the perpetrator, the responsible, and to put them to justice. After, we hope, we will have the effect that it will prevent others to do the same. Your question was?
Are we seeing from the international community any real efforts to actually create more of an interventionist approach? I'm not questioning the role of the ICC. What I am questioning is the fact that its existence is a poor second prize to actual intervention at the time of the conflict. And so I'm saying, are you?
It's your reflection.
Are we seeing any signs from the UN or the international community that they're likely to take more of an interventionist approach in conflicts that may arise in the future?
Of course, what your argument is the prevention of crimes,
yeah.
And the only solution is an intervention by the UN. I don't know, peacekeeping. I don't know, diplomacy. I don't know, politics. I don't know. I am just a prosecutor, so I have enough to do. I have enough to do with my work. But thank you. Sorry if you are not satisfied, but I'm just a prosecutor. I would maybe ask my political advisor to give you the answer you know.
Let me take the prerogative of Dean to ask a question myself. Hard question. The Kennedy School prides itself on training people who are going to be leaders, who might participate in your kind of activity, but also who themselves might lead states. Someone in the audience may well become a head of state. They certainly will work to promote the fortunes of other people. What are the qualities of leadership that, number one, seem to prevent this kind of activity, and number two, we should worry about in potential leaders, that so as to not have to have too many tribunals to deal with the kinds of issues you deal with?
That is also not a question for a prosecutor. But you know, the quality of a president, the quality of minister, the quality of each person is the same. The honesty and because you know we see by our accused what was that make them responsible for crimes. It was the managing the power in a distort way, let's say. I'm sorry, but I don't have probably the right terms for that. But I think that it is almost when our experience shows that when you are in power, when you have power, it is difficult not to abuse. And that is one of the quality, not to abuse of the power that you can receive or achieve.
Thank you. Right up here.
Good evening, Madam Prosecutor. My name is Ivana Josipovic. I'm a senior here at the college, and I come from Croatia. One of the things that I appreciate the most about the ICTY is its openness and transparency and the ability for people to watch the trials, read the transcripts, etc. There's a great educational potential there. Yet if one takes a look at the public statistics in the Balkans, a lot of people still do not accept that there were war crimes committed. In Serbia, majority still denies there were any war crimes, not to mention genocide, committed in Srebrenica. And the statistics in Croatia with the Operation Storm are very similar. So here's my question for you. Primarily, do you think that it is possible to have full reconciliation in the Balkans unless there was also full acceptance of war crimes that were committed? And secondarily, where do you think this discrepancy comes from? Do you think it is some domestic political factors, such as the politics of the radical circles, which are preventing people from learning more about this? Thank you.
Yes, you have the answer. It is politic. It is always politic who interfere first, or try to interfere in our work, and of course, make it more difficult to obtain a reconciliation. But I think that the way is now in the right direction, but it takes much more time. We cannot hope that from one day to the other or from 1 year to the other reconciliation is established. But of course, what we are doing at the ICTY is for sure positive for that. First, because we are working for the truth from the facts. After, we must ensure that the truth is coming out in the people, in the public, in the population. And third element is the recognition of the real truth of the fact. Because you must not forget that in Serbia, for example, 10 years Milosevic in power, that will mean 10 years of disinformation. So it takes time until you achieve, but the direction is the right direction. And I think you are not up to date of the statistic. It is not more than 40% that are supporting Milosevic now in Serbia. It was before that he had the majority. Now we have the majority.
Right up here.
Yes, my name is Marco Sharma. I'm a mid-career student here at the Kennedy School, and I used to work on the Middle East. As you know, Saddam Hussein is currently being tried in Iraq.
Yes.
And he's being tried by an Iraqi court, and many would argue that he would be the perfect example of someone who should be tried in an international court. Obviously, as you said, there's politics involved, but I just wanted to have your comments on that development. Is this something you welcome, or is that something that should be channeled in other ways? Thank you.
First of all, I must tell you that I must be very cautious in what I'm saying about Saddam Hussein, because otherwise tomorrow I will be called at the headquarters in New York, and I will not have a reprimand that I express my personal opinion. But what I was said even before, and nothing happened, and I can repeat it here, that I think that if you want to be sure that Saddam Hussein have a fair trial, he should be tried outside Iraq, because it is extremely difficult, particularly for the witnesses, for the protection of witnesses, for the courage of witnesses to testify in Baghdad. And we saw that in our Milosevic trial, because we have difficulty even in The Hague to have witnesses testifying. But it was decided different, and I must say I'm following very closely and with a lot of interest to this trial, and I was very unhappy when because we were asked to help the judges and the prosecutor in Iraq when they were in London, to go there to help for pass our experience and what we have done. But New York forbid us to do it, and I was very, very unpleased about that.
Thank you.
Right here.
My name's Mary Black. I'm a Harvard School of Public Health graduate in 1990, and I've been involved in the Balkans for about 15 years now. So as a doctor at all stages, kind of the whole lot, but mainly on the humanitarian side and a bit of human rights documentation. I find you fascinating because I could count on two hands the number of women that have any kind of a prominent role or voice in this whole thing. And I'm always intrigued why, because there's been so many men involved. Osran mentioned they go off and they write books. They usually do after about 2 or 3 years, but you, to me, are fascinating because you just stayed on for years, and you're one of the few prominent women in the whole conflict. I'm really interested in your motivation as to why you stayed on. What kept you going?
I have to answer. One is that the only activity that I can do is to be a prosecutor, because I'm since I was very young prosecutor, so I cannot do nothing else more than to be prosecutor. So I stay. But that is just for a little bit for joke. No, and I must confess that sometimes I have some crises that I will stop. But I must tell you, sometimes it is always in the evening that I say, what I am staying here any longer. No, basta, I will stop it. I got enough, really. It's particularly when I'm frustrated, when I cannot. You know what? I'm always telling me, when tomorrow morning I stand up and I have the same sentiment that I got enough, I will resign. But until now, I'm standing up in the morning and I'm full of energy and I start again. So you know, as I'm saying always, and so it seems a little bit not true, but it is, because I'm always repeating the same. I do that for the victims, because the contact with the victims are for me the only moment that I am emotionally involved. I can go to see mass graves, I can go to see bodies, I can go to see nothing. I am really, it's not touching me because it's our work, because you cannot be involved, because otherwise you cannot do this job, because you are confronted each day with incredible thing. But the only moment that emotional I am involved is in the contact with the victims, because the victims are asking for justice, and that is what is my main motivation, because why I'm staying and I'm trying to do my best. Thank you.
We have time for 2 more questions.
Good evening. I'm Goga Bukmirovic, a student at the Harvard Business School. And I'm wondering, given the amount of time that's passed since the end of the war and everything else going on in the world right now, is there the necessary political will necessary to exert the pressure in Europe and the US to bring Karadzic and Mladic to The Hague? And if they're not brought to The Hague by the end of the year, what is the likelihood that the tribunal will keep its doors open past 2010 to prosecute them?
I think that the United States are supporting us, and I don't know if you read the declarations that Ambassador Burns made during his trip in Belgrade, Karadzic and Mladic to The Hague, and of course they have an important leverage in the certification by the financial help to the Balkan states. So United States are supporting us fully. Of course, I was asking Secretary of State Condoleezza Rice, I need a little bit more intelligence to locate Karadzic, because I don't know who is working really to locate Karadzic. I have no information about Karadzic. I have no information about the existence of Karadzic in the last 3 or 4 months. And, sorry? Only his books. Only his books, yes, because he published a book 2 weeks ago. And of course, Secretary of State told me, yes, we will look if we can put more intelligence. But you see, prosecutor, we are using a lot of intelligence to locate Bin Laden, and we are still on our need. So full support from the United States.
Last question.
My name is Vladimir Ilic, and I go to Boston College School of Management. I'm originally from Bosnia. The work you perform is extremely public, and it creates a grim picture in the West about the Balkans, both on the individual level as well on the business level. I believe that this discourages investment in the region and kind of creates hardships for the entire region. Is there a way to perform your work less public in order to actually kind of improve the economics also of the victims as well as all the people there?
Yes, I would be very, very happy if I can do my job not so in public, particularly about the threats I receive. That will be positive if I could work. But it's not possible. It's not possible. And because transparency, because it must be known what we are doing, it must be shown, it must be discussed, and so when I'm meeting, I'm going to Zagreb, to Sarajevo, to Belgrade, meeting with the authorities. We have each time after the meeting the encounter with the press, and you cannot avoid that. Because we have nothing to hide. How do you say, to hide? And if the authority requests our presence with them for the press, we are doing that. We are doing that, yes. It is important, you know. It is also the information. It is also an outreach program. Thank you. No, I think I said all what.
Okay. Well, thank you very, very much for your terrific.
Thank you. Thank you. Thank you. Thank you very much.
Thank you all. Thank you all for coming out on a very, very nasty night. And again, it's a reflection of the importance of the work and the remarkable prosecutor that we're very glad to have had here. Thank you all. Have a safe trip home.